Breaking news out of the United States District Court for the Northern District of California. The City of San Jose's laws requiring a fee be paid by gun owners, and that the gun owners in that city be required to acquire liability insurance in the event that they do something wrong with their guns. That law has been upheld as constitutional by a judge that obviously has not taken her job that seriously as I see it. We're going to explain why I think that in 1 second. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. We want to learn from the mistakes of others so we don't make the same mistakes ourselves here in America as Second Amendment supporters. Okay, folks, so the United States District Court for the Northern District of California, which is in and around San Jose and the tech system, Silicon Valley, a federal district court judge, Beth Labson Freeman, a appointee to the federal bench by Barack Obama, a Harvard law grad, looks to be basically a partisan liberal as best I can tell, ran for Congress, or I should say ran for political office, I believe at the age of 18 or 19, according to the bio I read, as a Democrat. So, she has, of course, come out in a ruling dealing with San Jose, the city of San Jose's laws, new gun control laws, enacted, I believe, in early 2022. One is a gun fee, basically, that says that you have to pay $25 to have guns, just to have. It's a fee. And also, you have to go out and acquire liability insurance so that if you accidentally do something with your gun or something problematic happens with your gun, the insurance will pay off the victim. Obviously, these are all the most modern type of gun control laws because these are brand spanking new ideas from the anti-gun movement that were adopted by San Jose, which again is in the heart of big tech land. So as a consequence of that, these are obviously made up laws. And believe it or not, shock of shock, this Barack Obama appointed judge has come out and said that these laws are consistent and do not violate the Second Amendment's right to keep and bear arms. I've read her 23-page opinion. It's not a serious opinion. I don't think she took this case seriously at all. She, frankly, phoned it in. She knew what she wanted to get to, the outcome she wanted, and got there. But not an impressive piece of work in any respect. She's obviously not stupid. She's got some good credentials. I believe her husband is a former major lawyer at a huge law firm. So she knows what she's doing if she wants to know what she's doing. But I think she phoned it in on this decision. And because probably she doesn't like the Second Amendment right to keep and bear arms. A big part of her background, by the way, she worked for the city, for a city office for many years. So she comes from a pro-government philosophy and background. So again, no shock that she would just phone it in and rule against the Second Amendment on both of these issues, both of which are wrong, and we're going to walk through why right now. To begin with, I want to mention the plaintiffs in this case. The two major plaintiffs in this case is the National Association for Gun Rights, and also there's a tax-related plaintiff, Howard Jarvis Taxpayers Association, which is a nonprofit out there in California, I believe. They were the two major plaintiffs in this case. They brought this lawsuit. In fact, it was a consolidated lawsuits that got brought together in front of Judge Freeman to rule on whether or not this law, which effectively these taxes, are unconstitutional under, among other things, the Second Amendment and the First Amendment. And I think the answer is they are unconstitutional, and I think that's where it's eventually going to get to, although not with Judge Freeman. It looks like she's already has a preconceived vision of where she wants to go. No shock here. So just as a reminder, the two ordinances that we're dealing with, one is the insurance requirement. Specifically, it's the requirement that gun owners maintain liability insurance. And then there is a second thing called a fee, the fee provision, and that fee is a payment of an annual fee to a nonprofit of the city's designation. I should mention that this liability law is to cover, among other things, covering losses or damages resulting from any accidental use, misuse, or use of a firearm. And again, the proceeds generated by the fee have to go to something relating to discouraging gun violence and discouraging the misuse and mishandling of firearms. That's where it goes. So let's start with the Second Amendment claim. The first error that Judge Freeman clearly makes is she says these laws do not implicate the text of the Second Amendment. As you know, if you're dealing with a gun ban case, an arms ban case, like an AR-15 ban or a magazine ban, you apply the Heller in common use test. Because this case involving with a fee for guns as well as an insurance mandate for firearm ownership, this is not a gun ban case. Therefore, the Heller in common use test does not apply. We then go to the Bruin methodology, which, as you know, I'm telling everyone repeatedly because not everyone gets this right. The Heller methodology, if you look at the text of the Second Amendment first, then you look at the historical analog laws, if there are any dealing with gun control at the time of the founding second, and then you look to what's known as called confirmatory tradition to see if there's anything later in time that confirms the 1791 understanding that text, historical analog, and then confirmatory tradition analysis that Heller did is now become the Bruin methodology because Bruin basically explained that in greater detail to make sure that the lower courts would not screw it up. Obviously, that is not working across the board because here we have Judge Freeman who has made these errors, and we'll talk about that in 1 second. So to begin with, she makes a huge merit stakes right off the top. It just sort of discloses where I think her mindset's at, which if you're a Second Amendment advocate or support the right to keep and bear arms, this is a hopeless case, a hopeless cause. You just want to lose fast and treat Judge Freeman as what she really is here, which is nothing more than a whistle stop on the way to the Ninth Circuit Court of Appeals. She's a bump in the road when it comes to this, but that's really what we're talking about here because she's going to rule against the Second Amendment. She already has twice in this case, and it's game over on that topic. So basically, the first thing she says is that the text of the Second Amendment is not implicated. Now, obviously, this is stupid. Let's just think about this for a second. What does the text of the Second Amendment say? It says the operative language, of course, is the right of the people to keep and bear arms shall not be infringed. Well, to keep means to possess. To bear means to carry, not hard. So now what Judge Freeman says is this is not impacting the text of the Second Amendment because it's effectively a fee and a mandate for insurance, and that doesn't implicate the text. Obviously, that's not true. And we know it's not true because that is the equivalent of saying that a poll tax on the right to vote does not implicate the right to vote, which obviously we know it does. Because again, the way to understand the text of the Second Amendment is you read the text itself as interpreted by the U.S. Supreme Court in Heller and Bruin, very straightforward, including the right to possess. That's the right to keep. Then you also ask yourself, what are sort of necessary preconditions or necessary implications of this in the same way that, for example, ink is necessarily implicated or potentially implicated or helps facilitate the right to free speech and the right to free press, the First Amendment. Even though the word ink does not appear in the text of the First Amendment, guaranteeing the right to free speech and the right to free press, it still is implicated because ink, phones, pencils, pens, computers, typewriters, printing presses all facilitate and support and help with people exercising that First Amendment rights. So here you have effectively a tax on the constitutional right to possess a firearm. Because if in order to possess a firearm in San Jose, you've got to pay money to get this insurance, okay, assuming you can even get it. And the second thing, of course, is you have to pay the fee. So obviously, this is a burden upon the text of the Second Amendment because it impacts the right to possess because you cannot possess, i.e. keep, an arm unless you jump over these two hurdles, which means obviously it's implicating the text of the Second Amendment because it's a precondition or obligation that you have to fulfill before you can even keep, i.e. have firearms. So obviously it does implicate a Second Amendment right to keep and bear arms because, again, you can't exercise that right unless you do these two things. So obviously it implicates the text of the Second Amendment. Now she said it didn't, but she goes on to talk about the analogues, again, not in a very serious way. She basically says two things. She says that the surety laws were analogous here. Now surety laws, just to jog your memory, these were dismissed in Bruin. The way the surety laws worked in the early 19th century, okay, was that if someone like your neighbor threatened you, and your neighbor then went to court and had a trial in front of a judge, and the judge, after the trial in which you participated, because you had notice an opportunity to be heard, and you participated, if after that trial, the judge found that you were a threat to your neighbor in some violent way, the court could require that you post a surety bond, sometimes referred to as a peace bond, and once you posted that bond, you could continue to carry. Now, here's the thing. Those surety laws are very focused on people that were found by a court to be a danger to a particular person. What on earth does that have to do, and how is that a historical analog as a law to require every gun owner in the city of San Jose or anywhere to pay a fee that's ultimately given to a nonprofit that presumably doesn't like guns, right? That's the presumption. That's what I'm guessing will happen. And also require a mandate of insurance, which was never required at the time of the founding. In fact, I don't even think it's been required at any point, even in the 20th century. It's a brand new phenomenon made up by anti-gunner scholars, I suspect, who came up with this ploy to make it harder and harder to exercise a right to keep and bear arms because they want you to be a serf. They want you to be a subject. They want you disarmed. Because it's a lot easier to bully people that are disarmed. That's where I think the anti-gunners are really thinking about this big picture. But let's set that issue aside. So obviously the surety laws that Judge Freeman relies upon that I just described are very individualized and particularized, dealing with a one-on-one issue between you and, let's say, your neighbor, after a finding of fact by a judge that you're a problem. And then you just have to post the bond. Now, a general insurance policy applies to everyone, whether or not you've posed a problem to anyone or caused an issue or anything. You've never done anything wrong. You've never shown yourself to be a bad actor or a danger to anybody. So obviously, that is not a sufficient historical analog. Moreover, the Supreme Court says that when you compare analogs, which is just two things you compare, something to analog to something else, the Supreme Court says that the how of the analog, the how and the why have to line up. What that means is that the historical analog, in this case surety laws, the how it was implemented and the why it was implemented have to line up with the modern gun control law. So here, the how and the why of these taxes, for example, as I see it, the how is it's a tax on all gun owners. That's the how of the law. That's how it works. The why is pretty clear. It's about discouraging gun owners and to making the price of owning a gun more expensive, to discourage it. Now, you could take it at their face, and what San Jose says is to make sure that there's insurance in case something bad happens, there's money to be paid out to victims. That's the allegation. But if you go back and look at the surety laws had nothing to do with taxation. The surety laws were, if someone poses a threat to someone else in society, that's the why, right? It's not about making sure that victims have money in the event that they're injured by someone. It's to just say that if someone poses a threat to someone else, we want to discourage that threatening behavior from becoming actual violence by the posting the bond by that individual who we find in a court of law to be a threat. And of course, the how has nothing to do with insurance whatsoever. So, and the surety laws are likely too late in time anyway, because they weren't at 1791, I believe. Nevertheless, that's what Judge Freeman concluded as one historical analog. She also talks about something known as strict liability and tort law. She cites a couple of Massachusetts cases. I don't think, frankly, this has anything to do with the price of tea in China, because keep in mind that in the law of tort, and what tort law really is when someone acts negligently or recklessly and you get hurt, you can sue them civilly. So when you hear about crazy lawsuits over people that have spilled coffee or have, tripped over something, slip and fall cases, medical malpractice cases, professional malpractice cases, people get hit by a car, these fall in the civil law. These are all part of what's known as tort law, which is civil lawsuits involving people that have acted negligently or whose behavior has somehow fallen short of what is expected of them in our civil society. So she cites to a couple cases out of Massachusetts that basically said, according to her interpretation, is that the gun owners were held strictly liable for injuries caused by their mishandling of the firearms. Again, this is not a proper historical analog to either the gun ownership fee or the insurance, because obviously in these two cases, they involve people that had already allegedly acted negligently, specifically towards someone else, and they were sued in tort law. This has nothing to do to ahead of time, before anything occurs, you're forcing someone to pay money and to get insurance. So again, the how and the why don't line up between the historical analog that she's claiming, which are these two Massachusetts court cases, and one also asks whether or not a court case constitutes a tradition of regulation, because yes, court cases can be law, but they're not actual enactments of law like a statute or a regulation or anything like that. So one wonders whether or not these court cases even count as in terms of regulations, but even if they did, the reliance by Judge Freeman is simply not persuasive, because the how and the why of someone who's specifically found liable in tort has nothing to do with forcing people to buy this stuff ahead of time and imposing these costs. The other point I want to make is, of course, a lot of this, what she's relying upon is the wrong time period. Here's what she writes on page 11 of her decision. Quote, strict liability for gun accidents eventually transitioned to a negligence standard in the mid-1800s. Bing, 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 bing. Mid-1800s. Too late. Wrong. What does the mid-1800s have to do with the understanding of the Second Amendment of 1791? It was enacted in 1791. The mid-1800s have nothing to do with it. Everyone that was around in 1791 is dead by the mid-1800s, which is also around the Civil War, right? I mean, James Madison died, I think, in 1834. Jefferson and Adams died in 1826. So she's trying to rely on law for the mid-1800s, which is what I predicted on this channel right from the start. That's where they're going to go, because there's more crazy gun control laws, in part because of the black codes, all sorts of craziness. We won't get into the details here. The bottom line is they want to go to the mid-1800s, the late 1800s, because there's just more gun control law for various reasons in American society. But that's where she goes, wrong time period, and she admits she did the wrong thing, but she doesn't say she did it wrong, but she admits right here she's relying on mid-1800 laws. That is the wrong time period. More than that, here's the other thing. This is very amusing. She gets it. This teaches me that despite her Harvard Law degree, she's not trained in economics. If we only knew a handsome YouTuber out there that was trained in economics that could help us, help her understand, oh yeah, I think we know someone like that. Let me explain where she's gone awry on this point. Here is what Judge Freeman writes, trying to justify the fee and the insurance mandate. Quote, this is what she writes, quote, both regulations share similar, albeit not identical, deterrent purposes. Surety laws were intended merely for prevention of future harm, while insurance requirement is intended to reduce the number of gun incidents by encouraging safer behavior. Well, let me tell you something, the judge, first of all, you're not supposed to be engaged in this kind of analysis in terms of cost, benefits, and good and bad of law. Set that issue aside. That sounds like interest balancing to me, but let's assume she's not trying to do that. Ever hear the concept of moral hazard? Moral hazard. If you're not familiar with the term moral hazard in economics, let me bring you up to speed. Moral hazard is something that creates an incentive for bad behavior, or something that creates an incentive for worsening behavior. For example, a classic example of a moral hazard are seatbelts. So when people put on seatbelts, many times they feel safer and actually may drive less safely and more recklessly because they feel safer. Likewise, it's always been discussed that insurance is in some ways a moral hazard. How so? Because once you have insurance and you realize, well, if I screw something up and something goes awry, I'm going to have insurance. I'm not going to have to pay. My insurance company's going to have to pay. You've created what's known as a moral hazard. You've created arguably less of an incentive to be safe. You've actually increased the risk of something bad happening. That is why these things like insurance are called moral hazards, which is exactly what's going on here if you think about it. Because if you have insurance and something goes wrong in San Jose, guess what? That's going to be given to an insurance carrier, and you're not going to have to pay out of pocket on all likelihood. So you've actually encouraged in some ways bad behavior with guns. I'm sure that the gun owners in San Jose won't do that, but you actually understand that this works in the reverse way. The causation is reverse of the way Judge Freeman describes her opinion on page 12 here. These laws actually create moral hazards, but again, it has nothing to do with actually trying to do anything other than to make it harder to own a gun in San Jose. Let's not kid ourselves. That's the harsh reality, but they don't want you to have a gun and they want to make it hard and expensive as best they can. The other two critical things I want you to keep in mind about these insurance laws is, again, she reaffirms also on page 13 that she's relying on quote unquote 19th century surety laws. Too late, right? Too late. Beyond that, here's the other interesting thing she says. She talks about how that over time, if you're a safe gun owner, you'll wind up paying lower premiums than if you're a less safe gun owner. Well, that might be in theory true, but here's the reality of it. Are you familiar with something called ESG, investing? Environmental Social Governance, ESG. You probably have read about this. This is a liberal concept that is supposedly, let me tell you what the reality of it is, as I see it. This is my opinion. ESG programs are really about imposing standards on corporations to do what the left in America wants. So trust me, if you think about what's going to happen, once they require gun owners to get insurance, what will the anti-gun finance guys in big tech and on Wall Street and the big money guys that hate guns, what are they going to do? I'm going to tell you what I think they're going to do. And I'm pretty good at this because I know a lot of fancy-dancy people on Wall Street and around the world that are very wealthy, finance guys. That's where I, made my money as a Wall Street lawyer. A lot of fancy finance guys, and I know how they think. Let me tell you what they're going to do. They're all going to have meetings. They're all going to have lunches and dinners and go to parties, and they're going to chat with friends they know on the boards and in the offices, the C-suites, if you will, of insurance companies, and they're going to encourage insurance companies not to write these kinds of policies. So what's going to happen is they're going to put gun owners between a rock and a hard place because they're going to pass laws that say you have to have insurance to have guns, and at the same time, behind the scenes, you bet my bottom dollar on this. I'm telling you, this is what will happen down the road. They will use things like ESG programs and the like, and they'll pat people on the back, and they'll have meetings in their boardrooms quietly over lunch and things like this, and they will try to talk to the insurance companies and the finance people involved with the insurance industry to try to discourage the writing of these policies. Or if they're going to write these policies, they're going to encourage them to drive up the insurance rates. That's what is going to happen, is my best prediction. Now, beyond that, I want to point out there's a couple very basic rules here that are really simple that this case would be easy to resolve if the judge took it seriously. This is clearly a burden, a tax on gun ownership. And we know there's at least two Supreme Court decisions that are right on point as I see it that would knock these laws out. The first is, of course, the Minneapolis Star case from the 1980s that says that a tax on ink is unconstitutional because ink, even though it's not in the text of the First Amendment, violated the First Amendment's right to free speech and the right to free press, and therefore the Supreme Court said that laws imposing taxes on ink was unconstitutional. Moreover, we're talking about a $25 fee here plus insurance, which I'm sure costs more than $25 a year. Take a look at the case called Harper versus the Virginia Board of Elections. Harper versus the Board of Elections. That struck down. That's a U.S. Supreme Court case that neither of these cases conveniently are mentioned in Judge Freeman's decision, but that is a Supreme Court case that says that a $1.50 tax to vote was unconstitutional because you could not burden the right to vote even $1.50. Never mind $25 or more. So these are straightforward laws. Neither case, surprisingly, finds its way into this opinion. I wonder why not, because again, I suspect that the judge has really just phoned it in on this opinion, did what she thinks she wants to do. She does cite to some interesting case law. Let me distinguish it real quick. On page 14, she talks about a series of cases upholding before Bruin, certain fees associated with the right to carry guns. Okay, but none of that's going to fly because, again, the Supreme Court repeatedly says that this is a fundamental right and should be treated as such. She's trying to wiggle around here because here's the other thing. These fees that she's talking about on page 14, if arguably could be fees associated with covering the cost of the application. So, for example, there is law, I don't think it applies in the context of the Second Amendment or the First Amendment, but there is law, generally speaking, that says that the government can charge you a fee to cover the cost to the government of the service. So if they're providing you $25 worth of services when you go to like Yellowstone, they're allowed to charge a $25 fee to offset the cost of the services they're providing to you at like Yellowstone National Park. What they're not allowed to do, though, is if it costs $25 to provide you that service, they're not allowed to charge $200 and pocket $175 because then it becomes a tax, which is not legal for a whole host of reasons. And also in the context of the First and the Second Amendment, it's unconstitutional. So the cases that she's relying upon here on page 14 are really fee cases associated with the cost of processing concealed carry permits before the Bruin decision was decided. And yet she hangs her legal hat on these cases. I think that's just bad judgment all the way around. But again, I don't think she's trying that hard. And I think she thought it was close enough and good enough for, shall we say, government work, which of course she works for the government. And that's why I think she cited these clearly inapplicable cases. The last point I want to make there is speaking to the First Amendment issue here, why I think this fee at least violates the First Amendment is there's binding Supreme Court case law in a case among multiple cases, but the most recent one is the National Institute of Family and Life Advocates versus Becerra out in California, 2018. This was a case that required pro-life crisis pregnancy centers in California to post signs and to hand out literature and to show information that was basically pro-choice or pro-abortion or providing people with information about abortion. This violated the views and the perspective and the opinions and beliefs of the people that worked in these crisis pregnancy centers. They sued, claiming this violated the First Amendment because it was essentially a form of compelled speech because they were forced to articulate speech that they did not want to articulate. And the Supreme Court says, yeah, this violates the First Amendment. In an opinion in 2018 by none other than Justice Clarence Thomas struck down this law. So it seems here that because this $25 fee is being used in part to go to nonprofits in the gun control space, I know they put some language here, but it can't be used for lobby and litigation. Yeah, but the reality is I'm sure this is going to be used for something that is not good for guns. It's going to be anti-gun stuff. They're going to try to they're going to try to generate fear or something like that about guns. So it's certainly going to be a view that American gun owners would not support. It's going to go to places and people that American gun owners would not support. And that way, it looks to me like it'd be a violation of the First Amendment. But again, when you deal with a judge like Judge Freeman here, that's, to me, in my opinion, phoning it in, none of those niceties. And by the way, surprise, surprise, again, I did not see her discuss or distinguish the National Institute of Family and Life versus Becerra and talk about why that basic black letter Supreme Court decision on compelled First Amendment speech or compelled speech in violation of the First Amendment, why she didn't even try to apply it or distinguish it in any respect. It means she's, again, not really trying as best I can tell. Okay, folks, hope you learned a little bit something here today. The motion to dismiss brought by the defendants in this case involving the National Association for Gun Rights was basically granted. There's some niceties about some parts of the case that may still be alive, but we don't need to get into that today. So again, I hope you learned something here today. If you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.